Welcome, everyone. My name is Devin Driscoll, and I'm a co-chair of the law school's Board of Advisors Academic Engagement Committee, AEC. And we are a group of folks from the Board of Advisors who 3 or 4 times a year work with our amazing faculty at the law school to put together CLEs geared particularly towards our alumni. So we're really grateful for folks being here today. One elimination of bias CLE credit has been requested for today's presentation. At the end, towards the end of the presentation, we will put the code into the chat so folks are able to find that. But 1 hour of elimination bias credit has been applied for. And we want to make sure that we leave time for questions at the end of the panel. You should, at the bottom of your screen, see a Q&A function. And we will do our best to get to as many questions as we can. Appreciate folks, as the presentation's happening, feel free to just pop questions into that, and I will be monitoring it. With that, I'm thrilled to be able to introduce our speaker. Professor Jill Hasday is a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. She teaches and writes about anti-discrimination law, constitutional law, family law, and legal history. She's the author of 3 books: Family Law Reimagined from the Harvard University Press in 2014, Intimate Lies and the Law from the Oxford University Press in 2019, and the subject of our discussion today, We the Men, How Forgetting Women's Struggles for Equality Perpetuates Inequality, Oxford University Press, 2025. Intimate Lies and the Law won the Scribes Book Award for, quote, the best work of legal scholarship published during the previous year, and the Forward Indies Book of the Year Award for family and relationships. We the Men won the International Book Award for United States History and the National Indie Excellence Award for United States History. Professor Hasday, thanks so much for your time and sharing your insights today. Let's dig into our topic.
Thanks for having me. I'm delighted to be here. America's Constitution purports to speak for we the people. I wrote this book because too many of the stories that powerful Americans tell about law and society include only we the men. I argue that America's dominant modes of forgetting about women perpetuate injustice, and I believe that remembering women's stories more often and more accurately can help the nation advance towards sex equality. In my time today, I'll briefly overview the book before turning to my proposals for law reform. The first part of the book is called Erasure. It focuses on one way of forgetting about women that predominates in America's stories about itself. This strategy centers on simply ignoring women and their struggles for equality. Some examples are concrete, literally. Only 3 women made a recent list of the 50 most frequently commemorated people in America's public monuments, compared to 44 white men, many of them slaveholders. Women's erasure also runs through the stories that powerful Americans tell with words rather than blocks of concrete or stone, politicians delivering odes to America on significant anniversaries, commonly celebrate the founders for establishing government by the consent of the governed. That account depends on excluding almost everyone who is not a white male property owner. Supreme Court opinions regularly ignore women when remembering the court's key decisions. For example, the justices are obsessed with what they call Lochnerism, but the justices say little or nothing about the court's long and remarkably persistent practice of reasoning about the Constitution on the premise that women rather than men should prioritize domestic responsibilities. I call that ongoing tradition Mullerism, after a pivotal early decision that permitted states to impose sex-specific restraints on women's work. Similarly, law professors making lists of the Supreme Court's most important or most terrible constitutional judgments routinely omit decisions about women's rights. In fact, I was surprised to discover how frequently legal authorities and popular writers marginalize women even within discussions of women's status. When judicial opinions mention women, judges on and off the Supreme Court often write as if men decided on their own to expand women's rights and opportunities. I call these tales spontaneous enlightenment stories, and they feature in generations of popular press and political debate as well. These stories attribute progress to consensus and men's wisdom, while erasing the conflict and female agency that forward momentum required, with women needing to fight for reform against determined opponents. For example, it remains all too common for judges, politicians, and textbook writers to describe the 19th Amendment as a gift from men that gave all women the vote. That account is doubly misleading. First, the 19th Amendment prohibits sex-based denials of the franchise, but framing that amendment as conclusively establishing women's access to the polls misdescribes reality and implicitly centers white women. Laws on the books or tactics on the ground have denied many women the vote since 1920, especially women of color. Battles over voting and voter suppression rage to this day. Second, the 19th Amendment was not a gift. It was a multi-generational battle that required suffragists to overcome furious, sometimes violent opposition. Suffragists were shot at, assaulted, knocked from picket lines, dragged on the ground, arrested while their assailants went free, brutalized in prison, and force-fed. American newsmen were unable or unwilling to provide detailed accounts of anti-suffragist violence, which helped shield the violence from scrutiny. A suffragist artist refused to let the violence go undepicted. Katie, can you show the first slide? Katie, can you advance to the first slide?
Yes, I'm working on it.
Okay. There it is. Okay. This is Nina Allender's cover art for a September 1917 edition of the suffragist newspaper. It shows a male mob surrounding suffragists to wrest their banners from their hands and destroy them. As you can see, one delighted hooligan has ripped the word democracy from a woman's banner and claimed it for himself. I'll turn now to part 2, which I call distortion. This part focuses on a second form of forgetting in America's dominant stories about itself, forgetting the work the nation still has to do. As modern Americans, many of us have probably encountered people who announce or assume that the nation has left the sexist bad old days behind. Still, I was surprised to discover just how early in American history those premature declarations began appearing and how important a role they have played in perpetuating inequality. Wildly exaggerated accounts of America's progress towards sex equality have been common in both everyday settings and legal institutions since before the 19th Amendment's 1920 ratification made sex-based disenfranchisement unconstitutional. Elites routinely frame these declarations in terms of American women generally, but white women tend to be top of mind. The stories forget what remains undone, even to the extreme of proclaiming that America has already achieved sex equality. For example, a 1918 textbook assured young readers that, quote, all men and women are regarded as equals before the law. At the time, 33 out of 48 states maintained sex-based restrictions on voting. Although women had spent decades mobilizing for equality, discrimination against women at work, in marriage, and in every other arena was still pervasive and perfectly legal. Judges, meanwhile, have been suggesting or proclaiming that the nation has moved past sex discrimination for almost as long as American women have been mobilizing to challenge male supremacy. In fact, many of the judiciary's sunniest proclamations about American progress have appeared in decisions denying women equality, as courts rationalize their rejection of women's claims by contending that women already have so much. I call these decisions self-contradictory victory announcements because judges boast about America's embrace of sex equality while simultaneously enforcing male supremacy. Women are not the only marginalized group to have experienced the judiciary's self-contradictory declarations, but cases perpetuating women's inequality have long been prominent triggers for self-contradiction. Over the course of the 20th century, courts repeatedly announced that women's legal status had been transformed, while issuing judgments that enforce women's inequality. For example, the Supreme Court's 1961 decision in Hoyt v. Florida upheld a Florida law that kept juries all male and denied female defendants juries of their peers. While siding with Florida, the court suggested that Gwendolyn Hoyt's objection to the law was unimportant because women already enjoyed, quote, enlightened emancipation from the restrictions and protections of bygone years. I'll turn now to the third part of the book called Consequences. This part examines how the myth that sexism is confined to history warps the present. The first half of part 3 is about the law that courts have made in the late 20th and early 21st centuries. I focus on 5 U.S. Supreme Court decisions, along with many state cases. This chapter reveals how the modern Supreme Court has relied on the premise that the nation has left sexism behind as a reason to avoid examining how contemporary practices perpetuate gendered inequality. I demonstrate how the court has deployed that strategy when affirming the constitutionality of women's exclusion from military registration, sex-specific statutory rape laws, and a sex-based rule governing the citizenship of non-marital children born abroad. State courts have proceeded similarly when enforcing hostility to alimony and leniency about marital rape. I began writing this chapter before the Supreme Court announced Dobbs, the 2022 decision removing federal constitutional constraints on legislative power over abortion. I knew that the court would be hostile to abortion rights and inclined to uphold the law at the center of the Dobbs litigation, Mississippi's Gestational Age Act of 2018, which prohibits abortion after 15 weeks of pregnancy, except in a medical emergency or in a case of a severe fetal abnormality. But until I heard the Dobbs oral argument, I actually did not expect the court to overrule Roe in one fell swoop. That said, the Dobbs opinion ultimately felt very familiar to me once it leaked. Much like many earlier judicial opinions, Dobbs repeatedly invoked overstated accounts of women's advances to defend the justice's decision to leap backward and eliminate a constitutional right that women had had for generations. For example, Dobbs sought to justify the justice's decision to give legislatures so much control over women's lives by announcing that, quote, women are not without electoral and political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. That line of argument turned on obscuring how far America still has to go. The court erased the women who lack access to the polls more than a century after the 19th Amendment's 1920 ratification. In fact, Dobbs upheld legislation that emerged from a state notorious for voter suppression. No one is elected to the Mississippi government without surmounting or benefiting from the state's gauntlet of systematic disenfranchisement. So who runs Mississippi? The court never mentioned this, but men held 85.1% of the seats in the Mississippi legislature that passed the Gestational Age Act in 2018. Dobbs also didn't mention that the Mississippi governor who championed the bill and signed it into law was the latest in the state's unbroken line of white male governors. Boasting about women's political power while ignoring these persistent disparities made it easier to deny how politicians can endanger women when constitutional safeguards disappear. The second half of part 3 focuses on activism outside the courts. Asserting that America has already established women's equality has helped a half-century of anti-feminists battle feminist mobilization and champion regression while simultaneously claiming to support women's rights. Opponents of the Equal Rights Amendment, whether today or in the 1970s and 80s, have insisted that the amendment is unnecessary because America has already vanquished sex discrimination. That contention rang through the halls of Congress as I wrote We the Men, deployed whenever federal lawmakers wanted to fight against recognizing the ERA as part of the Constitution. Anti-feminists have wielded similarly sweeping and premature pronouncements to oppose government support for childcare, combat abortion rights, and condemn affirmative action. The book includes a photograph of Phyllis Schlafly. Katie, could you advance to the next slide? Thank you. Schlafly was a conservative activist who spearheaded the battle against the ERA in the 1970s and 80s and created a playbook that generations of anti-feminists have followed since. This 1976 photograph from a Stop ERA rally in the Illinois Capitol Rotunda illustrates how Schlafly's campaign sought to present the ERA as unnecessary in a nation that had purportedly established women's equality. Schlafly was then in her 5th year fighting ratification in Illinois. You can see her singing into a bullhorn backed by singing supporters holding signs. One sign reads, "We have equal job opportunities." Another asks, "New Illinois Constitution provides equal work, equal pay. Why then ERA?" I'll turn now to the final part of the book called Hope. This part explores how Americans can learn from the past to change the future. The long record of women's struggles for equality makes clear that real progress has always required women to confront powerful opponents. I argue that America needs more conflict over women's status rather than less. Conflict can generate change. Patiently awaiting men's spontaneous enlightenment will not. The last part of the book highlights some of the unwon battles that need fighting or continued fighting to push progress forward now and over the long term. This unfinished reform agenda spans teaching, commemoration, political representation, legislation, litigation, and everyday life. I'll begin with teaching because it is so formative. Offering students more expansive access to the past can enrich their perspectives in thinking about the present and their vision in imagining the future. K-12 education is especially important because it reaches the most students, some of whom will never read a history book again. While K-12 classes will be unable to cover every detail of women's history, 3 overarching and interlinked points can be made clear, at least in jurisdictions where that's politically possible. The first is about inclusion. Women are not a sideshow to the main event, with stories that teachers or textbooks can skip or relegate to specialized elective classes. Women's experiences are just as important as men's experiences. A generalization about American history doesn't work as a generalization if it doesn't apply to women. Along the same lines, generalizations about women's experiences don't work as generalizations if they exclude some groups of women, like women of color. The second point to highlight is about conflict. Americans have spent generations battling over women's status under the law and in society. Consensus and men's spontaneous enlightenment did not drive progress forward, and neither did a few late great women acting alone. Progress has required concerted mobilization to overcome determined, sometimes even violent opponents. The third point to emphasize is about incompleteness. Women's rights and opportunities have expanded in myriad ways over time, but legal authorities have sometimes reversed women's hard-fought gains, and the persistence of women's inequality remains a fault line running through American history. Progress remains in progress rather than complete. I'll turn now to law school teaching, a subject close to my own heart. Law schools teach far fewer students than K-12 schools, but have outsized influence because law students are future lawyers, law professors, judges, and legislators. The same points about inclusion, conflict, and incompleteness that I highlighted for K-12 schools are vital in law school teaching as well. Opportunities to center women along with men abound. In constitutional law courses, for example, professors could foster discussions about expanding the lists of the Supreme Court's most important or most terrible decisions that regularly appear in legal scholarship and shape law teaching. Law professors devising and disseminating these lists routinely exclude cases about women's rights. If deployed differently, these lists could become opportunities to broaden conversations rather than keeping them narrowed on the same few cases. Students could consider why no cases about women's rights have made these lists and explore which cases might be worthy additions. For example, many of the decisions my book examines would be prime candidates for inclusion on lists of the Supreme Court's worst. I'll turn now to commemoration. Commemorations teach outside the classroom. When they thread stories about America through memorable occasions and ordinary days, we can absorb the lessons without ever opening a book. Too often, America's commemorations push women into the shadows and leave men alone in the spotlight. Transforming the commemorative landscape will be challenging. As my book documents, efforts to focus public memory on women have faced fierce opposition for generations. To just give one quick example, one of the many, many consequences of Donald Trump's reelection in 2024 is that Harriet Tubman is now unlikely to replace President Andrew Jackson on the front of the $20 bill. For context, Jackson was a slaveholder who forcibly removed Native Americans from their lands. Tubman was an abolitionist and suffragist who freed herself and hundreds of others from bondage before becoming a Union scout, spy, and nurse during the Civil War. But Trump has loudly opposed placing Tubman on the front of the 20 since the Obama administration first announced that plan in 2016. Commemorations are fought over precisely because they can be so powerful in shaping how Americans understand their past, present, and future. America needs both more commemorations of women and different kinds of commemoration. I have many proposals, but for purposes of this talk, I'll highlight the 250th anniversary of the United States in 2026 presents an immediate opportunity. Women have been eager from their first years of mobilization to tie their struggles for equality to milestone anniversaries in American history. Women pursue these efforts from the outside because the official commemorations treated women as an irrelevance or an afterthought. When Susan B. Anthony and other suffragists disrupted the official centennial ceremony in 1876, or when the National Organization for Women held a counter rally on the bicentennial in 1976, the men leading the official commemorations were busy proclaiming the founders had established government by the consent of the governed. That story depends on excluding the experiences of most people in the early United States. When the nation's 250th anniversary arrives, women should not be an afterthought and should not have to claw their way into the commemorations. When Americans remember the founding, we should remember all of it. Freedom and self-government were part of the founding, and so were slavery and subjection. The experiences of women, enslaved or not, were as much a part of the founding as the experiences of men. I'll move now from commemorations entangled in politics to consider political representation more directly. I begin We the Men by discussing Alice Paul's predictions at the end of 1922. Alice Paul led the more militant wing of the women's suffrage movement during the final push for the 19th Amendment. After the 19th Amendment's ratification in 1920, Alice Paul's enthusiasm was buoyant. She was only 35 when the 19th Amendment made sex-based disenfranchisement unconstitutional, and she already had helped women achieve a major victory against ferocious opposition. She saw no stopping point to what women could win in the century ahead. In December 1922, the Washington Times asked Paul to predict how, quote, modern feminism would shape the course of history in the next 100 years. Paul told newspaper readers that it would not, quote, require 100 years to elect a woman president of the United States, and that women would comprise half of the membership of Congress by 2023. So, where is the United States today, more than a century later? Our line of male presidents remains unbroken, and a 2019 survey found just a third of Americans reporting that their neighbors would be comfortable with a female president. As of December 2025, women fill only 28.2% of the voting seats in Congress and only 33.5% of the seats in state legislatures. Battles to secure women's equal representation in politics have been ongoing for over a century, and victory is not yet in sight. Of course, women do not all think and vote the same way, CEG Phyllis Schlafly, but Americans have never experienced what politics could look like and what it might do if women were just as likely as men to be in state legislatures, Congress, and the Oval Office. I'll turn next to legislation. The book outlines an ongoing legislative agenda that falls into 5 categories: the ballot box, the body, the bottom line, the balance, and the baseline. First, the ballot box. This talk can't detail all the ways the law could better protect and expand voting rights, but I do want to emphasize that voting rights are foundational to the ability to achieve all other political goals. Struggles over voting and voter suppression are ongoing, providing the backdrop to every other legislative battle. The second arena I highlight for legislative reform is the body. The Dobbs decision overturning Roe is one of the biggest feminist setbacks in American history. Dobbs exemplifies and exacerbates women's legal vulnerability in the United States. Powerful Americans have boasted from the nation's earliest days about America's commitment to liberty and self-government, even as they denied women those prerogatives. Women have many more rights and opportunities now than they had at the founding, but that fundamental contradiction persists. America continues to present itself as freedom-loving while withholding freedom from women. Katie, can you move to the next slide? Thank you. A young protester named Soraya Bada, actually a Georgetown law student at the time, highlighted that contradiction when standing outside the Supreme Court on the day the justices announced their decision in Dobbs. The sign she held transformed the national anthem from a celebration of freedom achieved to a launching pad for protest about the many Americans still denied self-government. It read, "We were never the land of the free." Today, much of American politics centers on conflict over whether women will control their reproductive capabilities and their own lives. Those battles will continue for the foreseeable future. And conflicts over reproductive rights are not the only examples of women's ongoing struggles to exercise control over their own bodies. At least 12 states still treat sex crimes more leniently if the perpetrator acted while married to his victim. These statutes deny women sexual autonomy and bodily integrity. It's long past time for legislatures to recognize that marriage should not diminish a woman's rights over her own body. The third arena I highlight for legislative reform I call the bottom line. No matter what rights exist as a formal matter, the ability to steer one's own life, access opportunities, and make decisions without the pressure of desperation often turns on finances. The pay gap between men and women has remained remarkably unyielding over time. More than 2 decades ago, in 2003, the median woman working full-time and year-round earned just 75.5 cents for every dollar a man made. That figure has budged little since, rising to just 82.7 cents in 2023. Anti-feminists recognize that this gap is galling. That's why they're so anxious to explain it away and insist that sex discrimination does not factor into its persistence. But studies confirm what many women know from personal experience. Sex discrimination at work remains widespread, limiting pay and denying opportunities. While quick solutions are elusive, there are proven reform strategies available that feminists should keep pushing more legislatures to pursue. For example, federal and state legislatures should bar employers from questioning job applicants about their prior salaries. The too common practice of asking about pay history before deciding what pay to offer can lock workers into a cycle of unequal compensation that they cannot escape by switching jobs. Federal and state legislatures should also do more to tackle pay secrecy, which allows employers to conceal their unequal pay practices. Unequal pay undermines women's ability to support themselves and their loved ones, and it's not the only obstacle, particularly for women raising children. Despite endless proposals, Congress has kept the United States as a global outlier and refused to create a federal right to paid parental or family leave. Government support for early childhood education and childcare also remains woefully inadequate. The fourth arena I highlight for legislative reform I call the balance. So far, my discussion of needed legislation is focused on expanding women's rights and opportunities, but equal responsibilities and equal rights are inextricably connected. The absence of one makes the other less likely, and together they create and confirm full citizenship. I'll turn now to one of those equal obligations. If military registration is to continue, Congress needs to include women along with men. Ending male-only registration has long been unfinished business, and that has become even more obvious since the military opened all combat positions to women as of 2016. Okay. I'll end my discussion of needed legislation by shifting from specifics to a baseline question. Will the Constitution include the Equal Rights Amendment's explicit prohibition on sex discrimination? The required 38 states have ratified the ERA, but the last 3 ratifications came decades after the expiration of the 7-year ratification deadline that Congress inserted into the 1972 joint resolution sending the ERA to the states. The crucial next step is to push Congress. Federal lawmakers should either directly recognize the ERA as part of the Constitution, remove the ratification deadline, or ideally both. Such congressional endorsement would make it more difficult for the Supreme Court to resist the conclusion that the ERA's ratification is complete. The court has never denied recognition to a constitutional amendment that Congress accepts. Even so close to the finish line, fighting for the ERA remains arduous. Continued opposition to the ERA fits within a long tradition of vehement resistance to expanding women's rights and roles, and the stakes are high. Most broadly, the ERA can help transform how Americans understand the relationship between women and the Constitution. Generations of legal authorities have excluded women from the center of constitutional law. Indeed, Justice Antonin Scalia argued in 2011 that the Constitution does not prohibit sex discrimination at all because, quote, nobody ever thought that's what it meant. Nobody ever voted for that. The current society wants to outlaw discrimination by sex. Hey, we have things called legislatures and they enact things called laws. Scalia added, quote, that's what democracy is all about. This was never a compelling argument. Men barred women from voting on both the original Constitution and the 14th Amendment, prohibiting states from denying any person equal protection of the laws. From that perspective, it's hard to see how abiding by what the men behind these constitutional provisions purportedly thought about sex discrimination would be a triumph of democratic legitimacy rather than an importation of past injustice into the present. But in any event, women are unquestionably not an afterthought to the ERA, Adding that amendment to the Constitution would affirm women's equal citizenship and women's centrality to constitutional law. Most practically, the ERA could help expand women's rights and opportunities. As my book highlights, ERA opponents have spent over a half century describing the amendment as simultaneously unnecessary and menacing. The first claim has always depended on denying persistent sex discrimination and dismissing ongoing disparities. The second line of attack has recently focused on arguing that the ERA would provide constitutional protection for abortion rights. That latter argument has an ironic dimension, as abortion opponents ordinarily refuse to acknowledge any connections between abortion rights and sex equality. But anti-abortion attacks on the ERA suggest the impact the amendment could have, eventually, if not necessarily, with the current Supreme Court. Embedding the ERA's explicit prohibition on sex discrimination into the constitutional firmament would provide a new, sturdier foundation supporting feminist advocacy about constitutional rights. I'll turn now to litigation. Litigation is not teaching, but success in court can turn on shifting how judges view the world. The history of women's activism offers abundant material for contesting the judiciary's tendencies to erase and distort women's ongoing struggles for equality. Of course, any discussion of litigation has to consider how receptive judges will be. As We the Men documents, the United States Supreme Court has been an obstacle rather than an aid to women's pursuit of equality for most of American history. I feel comfortable stating that the current Supreme Court majority falls within that obstructive tradition. In the near term, the court is unlikely to prioritize women's equality or to wean itself from leaning on exaggerations of American progress, recently evident in the Dobbs decision. But advancing women's equality claims at the Supreme Court is a multi-generational project, and sometimes feminists have to focus on setting the stage for potential victories in the years to come. Meanwhile, the United States Supreme Court is not the only important litigation venue. State courts and lower federal courts decide exponentially more cases and offer innumerable opportunities. There can still be maneuvering room for judges interested in protecting women's rights. I've saved a crucial arena for the end. In our everyday lives, we can all participate in fighting for reform and against regression. These opportunities extend from public domains like voting and demonstrating to more private ones like speaking with relatives, friends, and neighbors. I hope this book illuminates how America's dominant stories about itself shield inequality and encourage complacency by forgetting women's struggles for equality and forgetting the work the nation still has to do. Recognizing these ongoing patterns can keep us alert and ready to respond. We can look for opportunities to change minds and promote engagement. We can also share an overriding lesson from the past. The long history of women's struggles for equality makes clear that progress is unlikely to be quick, easy, or accomplished by anyone acting alone. Generations of women have learned that lesson and persisted nonetheless. Jill Ruckelshaus is one of them. Starting in the 1970s, she became a key figure, advocating within and outside Republican politics for feminist priorities like the ERA and abortion rights. Phyllis Schlafly, who was not a fan, called her the Gloria Steinem of the Republican Party. In 1977, Ruckelshaus spoke at a convention of the National Women's Political Caucus, a group she co-founded. Katie, can you show the next slide? Thanks. Ruckelshaus offered this clear-eyed assessment and rallying cry, which I've had hanging on my wall since before I went to law school. I'll end by reading it now. We are in for a very, very long haul. I am asking for everything you have to give. We will never give up. You will lose your youth, your sleep, your patience, your sense of humor, and occasionally the understanding and support of people that you love very much. In return, I have nothing to offer you but your pride in being a woman and all your dreams you've ever had for your daughters and nieces and granddaughters, your future, and the certain knowledge that at the end of your days, you'll be able to look back and say that once in your life, you gave everything you had for justice. Thanks for listening. I look forward to your questions.
Thank you very much, Professor Hasday. Well, folks, please do use the question and answer tool on the bottom of your screen if you've got questions. In the meantime, I have a couple to start us off, Professor. So You talked at the beginning of your talk, you mentioned the 19th Amendment and the idea that the right to vote was a gift from men. Before I went to law school and until I took a class from you, had heard the same story that I think many people have heard, that the use of sex in the Civil Rights Act of 1964 was inserted by Congressman Howard Smith of Virginia, who opposed the bill in an effort to tank it, and then ended up, not causing it to lose. And so it was again uh, uh, that story is about men and the mechanics of men trying to do things, and women being a pawn in that. Why do you think that's a story? First of all, do you want to talk about and undermine that myth about that particular example? But then also, why is that such a pervasive part of our discussion about women's rights in the United States, that they are gifts from men?
Okay, so thanks for that question. So I talk about this in the book. I think of this as like a reverse of the spontaneous enlightenment story because men are still in charge, but here they're motivated by pernicious desires rather than enlightenment. So the standard dominant story of how prohibition on sex discrimination in employment got into Title VII in the 1964 Civil Rights Act is that Howard Smith, a staunch segregationist from Virginia, added it in an effort to torpedo the bill. The idea would be like everyone realized that sex discrimination makes so much sense and prohibiting it would be so ridiculous that the idea is enough men would turn away from the whole idea of civil rights, which Howard Smith directly opposed. And the this story was told by the Equal Employment Opportunity Commission immediately after in justifying why they actually weren't going after sex discrimination. The idea this is a joke and it's by segregationists, this is not what we're supposed to do. And is told by the Supreme Court as recently as like 2 or 3 years ago. So very common story. And what's amazing about it is so many of these accounts don't mention women at all. And it is so easy to find the evidence of women's participation, among other things, on the day that Howard Smith, he does introduce the bill, and he definitely acts from mixed motives, although he's a longtime supporter of the ERA because he wants to help white women. But on the day he announces this speech, almost every woman in Congress, there's only like 11, speaks in favor of it. And there's all these there's all this material documenting how women strive to keep it in the House version, and then there's an effort in the Senate to get it out of the Senate, and they mobilize around that. There's just overwhelming evidence, and women's historians over the decades have, done various pieces of it. I talked about that, and then I added my own additional pieces of that story, and it's so striking that the story persists. And I don't feel like I have a perfect answer because it's so ridiculous. But my sense is that many courts or commentators look at a story in which only men act, and they don't think that that's suspicious. They just accept, like, of course it would be men acting about whether sex discrimination is prohibited, and they don't have a thought of, it just doesn't seem unusual that there would be no women who mobilized. And that's what's very striking. Similarly, the idea that men just decided in their wisdom to give women the vote, when you actually think about it, it's like ridiculous. How would that have gotten on the agenda if women hadn't fought for it for a very long time? But I think we're just, as a culture, we're very used to repeating stories where men are the key actors and women are either missing or they're the objects on which men act.
The version of history that I learned in high school, that Woodrow Wilson just very kindly got behind the amendment, as opposed to the folks
As
suffrage.
opposed to kicking and screaming, right, when you have no
Right.
other alternative. Yeah. And I mean, you see the 19th Amendment was a gift all the time. I mean, it's in the newspaper all the time. It's something, obviously, actually, I'll give you a recent example. So there were a lot of, I think there's two big myths about the 19th Amendment. One is the 19th Amendment was a gift. And then the other was the 19th Amendment gave all women the vote. There's been a lot of stories because the Trump administration has supposedly toughened up the citizenship test. One of the questions on the citizenship test is, when did all women get the vote? And the answer is supposed to be 1920, the 19th Amendment. That's just factually untrue. The US Constitution gives no one a constitutional right to vote. It prohibits certain forms of disenfranchisement, but to become a citizen, you actually have to say something that is just not true.
Well, we've got some questions now from our
Good.
audience as well. So this is from and I apologize if I mispronounce names. Tova Flyger. Do you have suggestions for particular cases to highlight women's history that should be taught in high school, at university, or in law school?
Well, I think anytime that anyone is teaching the Lochner case, they need to give equal space to Mueller. So just a little background. Lochner is this case where the early 20th century Supreme Court said it is unconstitutional to place limits on the working hours of bakers. And that becomes like, what is the worst insult in constitutional law? One judge accusing the other, one commentator accusing the other of being a Lochnerist or a practicing Lochnerism. One of my teaching highlights was I was once giving a workshop and I was once holding a workshop for someone and I gave what I thought was very constructive criticism and the man responded by accusing me of Lochnerism. Like that was supposed to be a devastating blow. And of course I accused him of Lochnerism right back. But often when Lochner is taught, it's taught as if the Supreme Court was opposed to restrictions on working hours because they thought the freedom to work yourself to death is what autonomy was. But a few years after Lochner, the court decided this other case, Mueller, when it upheld restrictions on women's work on the theory that men can live for themselves, but women have to live for others, and it's okay for the state to restrict their hours so they have the capacity to have children. So I think it's just a great example of teaching Lochner without Mueller. One, you're only telling the story of half the population, but you don't even understand the case you're talking about. Lochner doesn't actually talk a lot about gender because the court took men to be the default people, the default human beings. It thinks it can say individuals and actually only mean men. But when you juxtapose them together, you see that actually the court has radically different ideas about what it means to be a man versus a woman. And Mueller is really about men. And Lochner is really about men. Also, just one more thing, because obviously I'm on a roll. Lochner is overturned in 1937. It's only the law for like 2 decades. In contrast, Mueller, the idea that you can have sex-specific restrictions on women's work, goes into the middle of the 70s. So Mueller ends up being this constraint on women's work, which actually operates to keep women out of male-dominated jobs. Because if you have a limit, they're not going to hire you as the typesetter. They'll just hire men. So I think that's an example.
And it's as you point out, it's interesting that whereas Lochner is an insult one can hurl.
No one says you're a Muellerist. Like Muellerism is an insult only created by me, right? It's just not. It's never on a list of the worst cases. It's never talked about. Sometimes I ask students from like other law schools who've taught, did you even talk about Mueller? And they'll say either we didn't talk about it or it was like the Squibb case in some case book. It was mentioned I just think you're doing the students a disservice and you're implicitly centering men's experiences as what legal history is.
And now we've got a question from Nicole Lindmeyer, who notes that she's a 2001 alumna and a women's rights attorney. She's asking whether you're familiar with the Lanham Act used during World War II. It was a 1940 law authorizing war-related government grants to provide childcare services for women who were stepping into jobs that had been vacated by men serving overseas.
I mean, yeah. So one thing that is so interesting is how, I want to back up a little bit. During the Depression, women's rights are rolled back. For instance, the federal government passes this law, the Congress passes a law that says in doing layoffs, we're going to target people where both spouses work for the government. Not surprising, overwhelmingly, the one who gets fired is the wife. So there's a rollback. Then in World War II, all of a sudden, the government and war industries need female labor because so many men are going off to fight. And it's like amazing. The government figures out all these ways to help women work. So they're providing childcare. There's actually a whole system where after work, like there's meals you can pick up. It's like the government realizes exactly what women need to combine work and family, and they're able to do it. And one of the tragedies of the post-war World War II era is part of the return to normalcy that both the government and industry promotes is women have to get out of male-dominated jobs, and all that childcare support and stuff goes away. Most of the women who worked in World War II industries don't actually go home to become, they're not stay-at-home mothers. They just go back to female-dominated jobs that pay less. But that is, I think, this tremendously missed opportunity that the government saw what structures are in place to promote female advancement and then takes it away when it doesn't see a wartime necessity.
And Nicole notes the transition from Rosie the Riveter to Betty Crocker.
Yes, in fact, I think one reason the 50s promote domesticity so much is it's a way of marking like we're not in wartime anymore, going back.
Catherine Marquis Hirsch asks, could you please talk about whether you think at this point it would make sense to shift efforts against sex discrimination toward making law gender neutral, more in terms of the Human Rights Act, which includes sex and gender identity? Interested to hear your thoughts about issues with such an approach.
Well, okay, so first thing I want to say is because of the court isn't very interested in sex discrimination, but one thing it's done is it applies a higher level of scrutiny to laws that are explicitly sex-based. So at this point, there's very few explicitly sex-based laws. Like military service is only men are required to register is an exception. Some immigration law, it's easier to pass on your US citizenship if you're a citizen mother with a non-marital child born abroad. But in general, to the extent that there's still sex discrimination, it's not maintained through explicit sex-based rules. It's maintained through facially neutral rules, which have a disparate impact on women or individual acts of bias, etc. So that's the first thing I'll say. Second thing is, yeah, so I was on the working group for trying to get an ERA in the Minnesota Constitution, and we pushed an ERA that included like every kind of category you could think of, because obviously discrimination is multivariable, and so is equality. So I think all things equal, that's the better approach. At the federal level, because there's an argument that the ERA has already been ratified, I certainly think we should just push to get that recognized, because we're like on the cusp rather than starting over, because the federal amendment process is so anti-majoritarian, so difficult.
Well, Professor, you bring up, I teach state constitutional law. I'm a big fan of state constitutions. And so you mentioned the state ERA and your involvement in the working group there. Can you talk a little bit about where Minnesota is on the progress towards adopting an equal rights amendment?
Okay, so first thing I want to say is I think one of the unfortunate aspects of elite legal education is we focus so much on federal law because we're trying to set up students where they could practice everywhere. But there actually are so many opportunities at the state level. For instance, after Dobbs, a number of abortion rights groups were able to win really significant victories in state courts interpreting state constitutional law. For instance, even states you don't think of as, not Democratic-leaning states at all. For instance, in Wyoming, these feminist groups filed this great brief that was so Wyoming specific. Wyoming is the first state to extend voting rights to women. And they really said, like, this is our legacy for Wyoming. It was great. I just thought it was great. So I think there are a lot of opportunities at the state level. In terms of the Minnesota ERA, so when the Democrats controlled both houses and the governorship, they got through a lot of legislation that I've been like testifying for years. And that was the year it all got through. They didn't do the ERA, which was not a political decision I personally supported, but I wasn't in charge of it. The main obstacle to the ERA, both at the state and probably at the federal level, is abortion rights, which I think is interesting because abortion rights opponents usually deny any connection between sex equality and abortion rights. But when they're fighting an ERA, they say, well, if we have a guarantee of sex equality, that means women have to have control over their own lives and ability to access abortion. So realistically, I think that's the main obstacle, but I haven't given up hope. In fact, I think one of the lessons of the book left me actually very optimistic because it shows there's been so many other, I don't think we're living in an anti-feminist moment. I feel very comfortable saying that. There's been so many other anti-feminist moments, and these women persisted. They kept going, and eventually they got things. Every victory women have ever achieved has taken much longer than it should have, generations against ferocious opposition. That's just the reality.
Is that what, well, let me ask the question in a non-leading way. What was it that led you to want to write this book now?
Oh, okay. So I had the seeds for this book were in my head since I went to law school, and I remember sitting in class. All my first year professors were men, and listening to them tell stories about the law, and all the stories were actually about men, and either they didn't talk about women or at all, or it was like a footnote or an aside. And I thought, women are half the population. We're not a footnote. Why are you telling the story of the law as if it's really a story about men? Well, not even acknowledging that. It's just presented as this is the story. So I always basically had this kind of book in mind. And then the 250th anniversary of the United States is coming up in 2026. And that's what really got me to do the book now. Every commemoration, women have always been on the outside. Susan B. Anthony and four other suffragists literally crash the official centennial ceremony because they won't let them have a minute to speak about women's suffrage. They crash it. They have what they call like a women's declaration. They distribute it to the crowd. Because every important anniversary in American history, it's always that story of the founders established government by the consent of the governed. That's true for some people, but not for the majority of people. To tell that story, it requires treating women as an exception. We're not an exception. We're about half the population. So I wanted this book out in the world before the 250th anniversary, and that's what got me to do it now.
You, a little earlier, you mentioned the fact that at least in federal courts, we explicitly sex discriminatory laws would be viewed through a particular sort of in the middle level of scrutiny. And you also mentioned the 2016 decision to open all combat roles to women.
Yeah.
Recently, the Secretary of Defense has indicated that that policy may change either explicitly or implicitly. And I know in your 14th Amendment class, you talk about you theorize that if there was ever an actual challenge to male-only registration, that it would fall in the face of that level of scrutiny. What do you think is the case today as that policy is in flux?
Well, first, it makes me so happy that you can remember things that I said in class. That really makes me happy. Okay, so in 1981, the Supreme Court upheld the constitutionality of male-only registration, and the court's argument turned on women's exclusion from combat. The court said, we have male-only military registration because we have a male-only draft. We have a male-only draft because women are excluded from combat. And what was the court's answer for why women can be excluded from combat? In Roscoe, which is really popular. The president, Congress, everyone thinks it's a good idea. So that's Roscoe. So Roscoe really rested on this idea of women's exclusion from combat. Starting in 2016, there have been no sex-based combat exclusions. There still are gender-neutral tests. I mean, Pete Hegseth, I think, is not actually giving an accurate account of what the military does. There's sex-neutral tests you have to meet, and many tests, men are much more likely to pass, right? At this point, there's been at least one woman who's graduated from all the special forces schools. But obviously, for instance, the Navy SEALs are overwhelmingly men. And I don't think that's necessarily evidence of sex discrimination. That's just, men have more upper body strength, whatever. So there have been attempts to challenge the constitutionality of male-only military registration because the initial premise, women's exclusion from combat exclusions, is gone. There was a case, actually, the men's rights movement brought in the Fifth Circuit. The Fifth Circuit basically said, yeah, this is sketchy, or well, not exactly that, but they were like, yeah, this may be shaky, but who are we to question the Supreme Court? And because they left the male-only registration in place, the court didn't have to take the case. Three justices said, we're going to wait because we know Congress is going to get a right on it. So in 2019, I testified before the congressional committee about explaining why I thought male-only military registration is unconstitutional. Congress did have some hearings about the report that was produced, but nothing has happened. I think realistically, if there ever was a draft again, which is very unlikely, they would have to make it sex neutral. It's just not possible to defend. But we're in this is not the case the Supreme Court wants to take. Feminist movement has historical overlaps with pacifism. This is not, many people aren't interested in bringing it. And so we're just in this nether space. I know Pete Hegseth has expressed interest in excluding women from combat. He's also got a lot of pushback for that because generally women's increased participation in the military has been an area where the left and right actually have a lot of alignment. The left likes it for sex equality, but the right likes it for letting women into positions means you can basically take like the top, the most accomplished women, and you don't have to do the bottom of the barrel men. That's what we're talking about, realistically. These are still male-dominated spaces. It's about, can you take these very unusual elite women, and then you don't have to scrape the bottom of the barrel with the men that are at the bottom of the test. The military wants to take those elite women. It helps them. It's just a huge talent. It's just a huge talent pool. So, I mean, it's hard for me to predict the future, but I think there would continue to be quite a bit of pushback to pushing women out entirely in the military. It's easier for Hegseth to just fire female military leaders. He can just do that. But to actually, roll back women's access to these positions would be more difficult.
And as we're running up to the end of our time here, a final question from Celeste Cobrel. She notes she's a graduate from the class of 1981, and her first-year class included about 40% women, in marked contrast to all previous first-year classes, which had included only a handful of women at most. Laura Cooper had joined the faculty as the first female tenure-track professor and became the first pregnant professor. Now at the law school, female students are a slight majority, and female professors are not a novelty. What is the law school atmosphere like now? And I'll just add to that Joyce Hughes, who just passed away at Northwestern, where she was professor emerita, had also joined, I think, in the early 70s at the University of Minnesota Law School as the nation's first Black female tenure-track professor.
I think things have gotten much better, certainly for students. Things have gotten much better at the entry point for students. Law schools, women are either close to or a half of medical schools. What's frustrating is people, like especially anti-feminists, but more generally, say in the 90s, people said, once you get more women in the pipeline, there's going to be equal numbers of women at the top. And the problem is we just haven't had enough time, where the baby boomer women have, been in these careers for 20 years and they'll be the CEO and the president. And what's frustrating is that even though women are at this point near equal, law, medicine, actually pretty high in business, you don't see the same kind of replication in the highest levels, whether that's like law firm equity partner or tenured professor, et cetera. So I think, yes, it has gotten much better, but I would also say we could do a lot better.
Well, Professor, we appreciate so much your time today. We appreciate folks who joined to hear the conversation. I see that in the chat, the number for our CLE today, number 540778. We've applied for one elimination of bias credit, and we appreciate folks coming in and joining our conversation today. And your book will make a great Christmas present, a holiday present for folks. Professor.
Thanks for listening. I appreciate it.
Take care, everyone. Thank you.